Hey guys, let's talk about a case from 2021 related to a 1099-C for discharge debt and credit reporting. There's been a lot of questions about this, and I thought this would be an interesting opinion to look at. So remember this, with every opinion, you have to understand what's the background. And was this a trial? Was this a summary judgment motion where the judge says, no reasonable jury could find in your favor or your opponent's favor, and so the judge summarily enters judgment? Or is this a motion to dismiss, which is really based on what did the plaintiff, the one that brought the lawsuit, what did they say in the lawsuit or what's called the complaint? That can make a big difference here. We'll see this particular one is related to a motion to dismiss. So we have the consumer Lewis versus Synchrony Bank. There were some credit bureaus involved, and they all ended up settling. And ultimately, it appears that the case was settled with Synchrony as well. So Synchrony files a motion to dismiss. This is brought under the Fair Credit Reporting Act, and so they try to throw that claim out. And the trial judge, the district court, denies that. So here's the history. There's a Synchrony Bank card in 2006, and eventually $1,180 is owed on it. 2018, Synchrony issues a 1099-C, cancellation of debt, and states that $813 of the debt was canceled. And so then after they issued that, they reported to the credit bureau, so that would be Equifax, Experian, TransUnion, that his account balance remained $1,180. And then the consumer informed those three credit bureaus, Equifax, Experian, TransUnion, incorrect information was being reported. And then he says the bureaus notified Synchrony Bank, and Synchrony did not conduct an adequate investigation. That's their obligation under the Fair Credit Reporting Act, is Synchrony must conduct a reasonable investigation. And so let's look a little bit more at what's happened here. So March of 2020, the lawsuit is filed, and it says, hey, Synchrony, you violated Section 1681S, and more specifically, it would be 1681S-2B, which is what we call furnisher liability. And that creates a duty to investigate disputed information. Synchrony tries to dismiss the case, and they say, look, it fails to state a claim because the issuance of a 1099-C does not mean the debt was discharged. Now, this is an important point. A lot of people just get sort of sloppy with this, but we have to really follow what the judge is doing here, or we can come to the wrong conclusions. All right, so under what's called a Rule 12b-6 motion to dismiss, the court will accept all factual allegations as true, construe the complaint in the light most favorable to the plaintiff, the consumer, and determine whether under any reasonable reading of the complaint, the plaintiff may be entitled to relief. And then to sort of further this, it has to be plausible. So what does plausible mean? It's not a probability requirement. Plausibility means more than a sheer possibility the defendants acted unlawfully. So a claim has facial plausibility when the plaintiff pleads factual content that does what? That allows the court to draw the reasonable inference that the defendant is liable. And then they say, even if you do that, though, the complaint will not withstand a motion to dismiss if the facts alleged do not state a legally recognizable cause of action. And the court does not have to accept unwarranted inferences, unsupported conclusions, or legal conclusions disguised as factual allegations. Now, that's kind of a bunch of technical stuff. It's saying, look, we're going to accept what the plaintiff says unless it's just outrageous. Okay? So you've got to give us some facts, which that's not evidence. Sometimes defense lawyers get confused, even judges get confused. We don't put forth evidence in our complaint. Evidence is what we do in court. Here's a witness, here's a document. What we do in a complaint is we make allegations about what the facts are. And so that's what we're looking at here. So let's figure out what the FCRA is. So Congress enacted FCRA in 1970 to ensure fair and accurate credit reporting promote efficiency in the banking system, protect consumer privacy. So it's crafted to protect consumers from the transmission of inaccurate information about them. I mean, that's a great summary. Don't have inaccurate information on my credit report. So let's see what happens with both the bureaus and the furnishers. So the FCRA imposes duties on the CRAs, the consumer reporting agencies, or the credit bureaus, who prepare credit reports, and furnishers, that would be like Synchrony Bank, who furnish or provide credit data to the credit bureaus. So you have the credit bureaus, and sometimes they're called repositories because the furnishers, the data furnishers, are sending data to them, and that's where it's stored, is with the credit bureaus. So when a consumer raises a dispute to a credit bureau, that's critical, not just going to the furnisher, got to go to the credit bureau regarding information in his credit report. The CRA must notify the furnisher, that would be Synchrony, of that information. That's under 15 U.S.C. section 1681I. You can remember that section because just think of for investigation. You go to 1681I for investigation. So what does a furnisher have to do? And this is looking at 1681S2. The furnisher must A, conduct an investigation, B, review all relevant information provided by the Bureau, C, report the results of investigation to the Bureau, and if that furnisher finds information is incomplete or inaccurate, then it has to tell the other bureaus about that. So how do you, what's called, plead a claim? So what do you have to say in your complaint to make sure that you can actually go forward? Well, the court here gives us three things. That you inform the CRA, Equifax, Experian, TransUnion, that he disputed the information the furnisher provided. Number two, the CRA or credit agency, credit bureau, notified the furnisher, here's Synchrony. And three, the furnisher, Synchrony, failed to conduct a reasonable investigation. And then we talked about this in a recent case. What does accuracy mean? Well, it literally means accurate. Or it can mean, well, it's technically accurate, but it is misleading. Well, then that would not be accurate under the standard. So even if the information is technically correct, it may still be inaccurate if through omission it creates a material misleading impression. All right, so what do we have here? Synchrony says, as a matter of law, the issuance of a Form 1099-C does not mean that a debt is discharged. And so he obviously did not state a claim, so throw him out of court. So what's the deal with 1099-C? It's issued when an applicable entity discharges the indebtedness of any person during any calendar year. And so there are 8 events, and then one of those is discharge of indebtedness pursuant to decision by the creditor or application of a defined policy of the creditor to discontinue collection activity and discharge debt. Courts disagree as to the legal significance of the issuance of a 1099-C. So we'll come back up here. So most courts have held that absent other evidence, that's pretty important, absent other evidence, the issuance of a Form 1099-C does not automatically discharge a debt. A small minority of courts have disagreed, found that the issuance of a Form 1099-C alone does cancel a debt. So why did the minority courts say this? Because filing a 1099-C has legal significance to the debtor's income tax liability. And so if you're going to face penalties or fines, it would be inequitable to permit a creditor to collect the debt after having received the benefit of the, quote, charge-off of the debt from filing the Form 1099-C. So what does our judge do here? Well, he says, I'm not going to reach the decision. I'm not going to decide either the majority position or the minority position. Well, why? Because we're at the pleading stage. The consumer need not prove but merely plead plausibility the report was inaccurate and that Synchrony failed to reasonably investigate the dispute. So what does the complaint say? And this is where the details really matter. The complaint alleges that his debt was discharged. And then Synchrony continued to report the full balance. He disputed the accuracy. The bureaus notified Synchrony, and they failed to investigate. So look at this. Again, very, very important detail. Does not plead that the 1099-C itself discharged the debt. So the consumer is not saying a 1099-C equals the debt has been discharged or it creates the discharge, but rather the debt was discharged and then the 1099-C followed that. Okay, so here in the words, 1099-C served as memorialization. So defendant, this is a quote from the lawsuit, defendant discharged $813 of the debt, which was memorialized via 1099-C. Now, this is a distinction that some people will say, well, it's not really that important, but the judge here found it's important. We're not saying you issue a 1099-C and that causes the debt to be discharged. We're saying you discharged the debt and then you memorialized it. You noted it in a 1099-C. So it's premature to dismiss plaintiff's claims at this stage because his allegations of discharge are plausible. So here are some cases. Here's one from Pennsylvania, from Kentucky, Northern District, California. Denying motion to dismiss complaint alleging FCRA violation where plaintiff pleaded existence of 1099-C. And then there's a footnote that says, look, Synchrony cites a whole list of cases. They're all down here, supporting the idea that the issuance of a Form 1099-C does not mean that a debt is discharged, in line with the majority view. None of those cases, however, were decided on a motion to dismiss, and only one concerned FCRA violations. And then they say, Synchrony argues issuance of 1099-C does not mean Synchrony must cease furnishing information. They rely on FTC, Federal Trade Commission guidance, and the judge says that concerned time-barred debt, not what we're talking about here. So here's the summary. Accepting the well-pleaded allegations in the complaint to be true. Now, the judge saying, for right now, we're doing that. At summary judgment, you would have to prove this. At trial, you'd have to prove this. But accepting them to be true, including the allegation the debt was discharged, coupled with the issuance of 1099-C, drawing all reasonable inferences in favor of the plaintiff, court finds that the plaintiff, the consumer, has plausibly pled Synchrony violated the FCRA in failing to reasonably investigate the disputed balance. So the motion to dismiss is denied. Now, I know a lot of people want, I want the one true answer on if a 1099-C is issued. Does that mean that the debt is gone? And I did some videos on this maybe 2 years ago. And so you can just search on my channel for 1099. But keep this in mind. We sort of take this one step at a time. Here the plaintiff said, look, you did discharge the debt. And then you memorialize that in 1099-C. It's a pretty good argument, right? Because 1099-C talks about, let's go back up to here. So there are some events that trigger the filing and issuance of a 1099-C. One of those is discharge of indebtedness pursuant to a decision of the creditor to discontinue collection activity and discharge the debt. Now, let me just say this because there's a lot of confusion. And I understand these words are similar. And sometimes courts even use these imprecisely. But there's this argument out there that if your debt is charged off, well, that's the same thing as discharge, which is the same thing as a 1099-C, which is the same thing as nobody can collect it. It can't be on your credit report. That is not a logical argument. In other words, those things do not equal each other or they don't flow in that way. Now, it could be that your charged off debt is actually discharged and that a 1099-C has been issued and that it should not be on your credit report. But that's not true of every charged off debt. Lots of cases talk about charged off debt. You still owe that debt. Now, if the creditor says, you know what, we are discharging this and we're going to issue a 1099 and get a tax benefit, that's where the courts are split. What does that mean? And as this court said, most courts say just issuing a 1099-C on, quote, discharge debt. And when I say discharge, we're not talking about bankruptcy discharge, but just discharge debt. That does not mean it has to come off your credit report. But some courts do say that. So there have not been a bunch of decisions on this, and we'll just have to see how it goes. But I think this particular case, and this was a district court in New Jersey, January 28, 2021, can be very helpful to us and can provide a roadmap to how to plead these cases, how to write the complaint to give yourself the best possible chance of success. Okay, guys, thanks for watching this. Hope you enjoyed it, and I will catch you very soon. Okay, have a good one. Bye-bye.